Okay, we are now live streaming. We are on the record for Wednesday morning civil docket, November 17, 2021. Mr. Derek Salinas.
Good morning, Your Honor.
Good morning, sir.
Your Honor, I'm here on docket number 6. This is the friendly suit. The cause number is CL210179I.
Okay.
I'm standing in for Humberto Tijerina, the third judge. Michael Guerra is the defense counsel on this case. The ad litem on the case is Mrs. Kathy Alvarado, judge. I've got an announcement for all of us, Your Honor. The next friend is currently in the hospital. She's not able to attend this morning's final hearing, Judge. So respectfully, on behalf of everyone involved in the case, we're going to ask for about a 3-week reset.
Okay.
Try to finalize this thing maybe the 1st or 2nd week of December.
Do you think that the person will have recovered by then?
I think so. My office has spoken to her, and we talked about the 3 weeks, and she didn't think that would be an issue.
Okay, December 15th at 9:30.
Thank you, Your Honor.
Okay, anything else?
That's all I have before the court, Your Honor. May I be excused?
Yes, you may.
Thank you, Judge. Take care.
Likewise. Okay, Mr. Ramirez, Dennis Ramirez.
Yes, Judge, number 35.
All right, F 4733-21-9 in the interest of a minor child. I know that the mother was pro se. Was she making an appearance today?
Your Honor, she's retained Juan Ramos. He's on.
Okay.
Yes, Your Honor. I'm sorry. I filed a counter petition late yesterday, so I think the county clerk is still processing that.
Okay.
Your Honor, our announcement for this honorable court this morning is that the counsel and I have conferred. We have agreed with the court's permission to informally mediate in the next 2 to 3 weeks. If we're not able to come to a resolution, we will formally mediate. And we're asking the court, just in case, either as a prove-up or for a contested hearing following formal mediation, perhaps a hearing date if the court's available before the holidays, to have something in place for the holidays.
Okay, that's the thing, is I'm very stacked and I've already had my contested docket pretty heavy. So that was going to be my next question. Is there anything in place for Thanksgiving, and is there anything in place for Christmas?
Well, Your Honor, counsel and I have visited, and Mr. Ramos, being the professional that he always is, we have agreed with respect to Thanksgiving that we will enter into an agreement, and I fully anticipate we will resolve it, and I'm sure if we don't, that we'll be able to reach an agreement for the holidays. And the next available date the court has, we'll be happy, and we can live with that date, Judge.
Okay, so I can set you for a status on January the 26th at 9:30. That's the soonest that I can bring you in.
Your Honor, we know how busy the court is and how everything is, and we appreciate the court's time.
If you happen to get in a jam, call us and we'll figure something out, because I need these people to have something in place for the holidays.
Thank you, Your Honor.
Okay, anything else?
Nothing further on this case, and that's the only case I have before this honorable court.
Okay,
Same announcement for me, Judge.
all right. Thank you, gentlemen.
Thank you, Judge.
Okay, Mr. Kosofsky?
Morning, Judge. I'm here on item 31 on the docket, Serato v. State Farm.
CL 173694-I. And is Memo Tejerina coming on?
Your Honor, Gabriela Danis, I'm standing in for Mr. Tijerina today.
Okay,
Judge,
and what is the announcement?
we settled the case at mediation. I believe it was last week, or it might have been just the week before. We're still just waiting on some closing papers, but the case is resolved.
Okay, congratulations. How much time are you thinking you'll need?
I think it's probably just an extra week or two to get those paperwork in and all resolved, Judge.
Okay, I'm gonna set a tickler for December the 3rd, just to see that everything's already been filed by that date.
That should be fine, Judge. If everything is, do we need to, oh, it's just a tickler. It's not
It's
a
just a
status.
tickler.
Okay.
All right, anything else?
No, Judge, that's all I have. If I could be excused.
Yes, sir.
Thank you, Judge. Have a happy Thanksgiving.
If I
Thank
could-
you, likewise.
Bye.
Okay, Mr. Davis?
Yes, ma'am, Judge. I'm here on number 5 on your docket. It's a default divorce.
F 3869-21-9 in the matter of the marriage of Gladys Sierra and Rigoberto Sierra.
Yes, Judge, I represent the petitioner and she's here. The court's file should indicate that the respondent has been served a citation and petition, and the citation has been returned to the court's file, and it's been on file for at least 10 days. And at least 60 days have passed since the date of that we filed this petition for divorce.
Okay, and is Rigoberto Sierra present? Rigoberto Sierra? Rigoberto Sierra. Okay. No response? Go ahead.
Okay, well, if Ms. Sierra could be sworn in, I can.
Yes, and the court will take judicial notice of all the documents in the court's file. Ms. Sierra, English speaking or Spanish speaking?
English?
Raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, Mr. Davis.
Okay, Ms. Sierra, can you please state your full name for the record?
It's Gladys Mara Sierra.
Okay, and you filed this petition for divorce against your husband, Rigoberto Sierra, correct?
Yes, sir.
And prior to filing this divorce petition, you had lived in Texas for at least 6 months and Hidalgo County for at least 90 days, correct?
Yes, sir.
And you and your husband were married on December 21st of 2001, and y'all separated on October the 4th of 2011, correct?
Yes, sir.
Okay, and the marriage between yourself and your husband has become insupportable due to a discord or conflict of personalities that destroys the legitimate ends of the marriage, to the extent that there is no expectation that you and your husband will reconcile, correct?
Yes, sir.
Okay. Now, during the time of your marriage, you had 3 children, correct?
Yes, sir.
And their names are Rigoberto Sierra Jr., Katrina Sierra, and Christian Aguilar, correct?
Yes, sir.
And you're testifying here today, and as part of your pleadings in this case, that your husband, Rigoberto Sierra, is not the biological father of your son, Christian Aguilar, correct?
Yes, sir.
Okay. So with regards to you and your husband, y'all had 2 children that were born during the marriage, correct?
Yes, sir.
And y'all did not adopt any other children?
No, sir.
And you're not presently expecting a child, are you?
No, sir.
Okay. With regards to your husband, he presently lives in Mexico, correct?
Yes, sir.
And to your knowledge, does he have any ability to legally cross or come into the United
No, sir.
States?
No.
So you're asking the court with regards to your children, that you be appointed what's called the sole managing conservator of your children, correct?
Yes, sir.
And that any visitation in the future with the children and your husband will be by mutual agreement, correct?
Yes, sir.
Okay. Now, with regards to child support, you're asking the court not to order child support, is that correct?
Yes, sir.
And can you explain to the court why you're making that request?
Well, actually, when he got deported, the judge said he was not going to return ever. He was not going to return back. So he lost his residence.
Okay. So you don't think he'll ever
No, no
make
chances.
child
No.
support payments, even if it's
No.
ordered by the court?
What,
Is
can
that
you repeat the question?
Oh, okay. So you think because he was deported, that he will never make child support payments, even if the court orders child support?
Yes. Mhm.
Okay. And we've also explained to you that the judge may still order child support, but you're just requesting that there not be any child support.
Yes, sir.
Okay. With regards to your children's medical and dental support, are they covered by Medicaid?
Medicaid.
Okay. So we're asking for what's called medical and dental support from your husband in the amount of $117 per month. And you understand that money, if it's ever collected, will go to the state of Texas, correct?
Yes, sir. Mhm.
Okay. With regards to all these provisions regarding your property, are you asking the court to approve them because they are in the best interest of your children?
Mhm. Yes,
Okay. Yes. Okay.
yes,
With regard to the division of the marital estate, you and your husband have been separated for 10 years and y'all do not presently jointly own any property, correct?
no, sir.
Okay, so whatever property you have in your possession, you're asking the court to award it to you. And whatever property he may have in his possession, that be awarded to him, correct?
Yes,
And same thing for any debts either of y'all may have. Your
yes,
debts
sir.
will be assigned to you and his debts will be assigned to him, correct?
Yes,
Okay. Do you want to have your last name changed or do you want to keep it as it is?
I mean, no, I mean, that's okay.
Okay, so you're not asking.
I'm just gonna stay like that, yeah.
Okay. And you're asking the court to grant the divorce, correct?
Yes, sir.
Okay. Judge, I think that's all we have.
Okay. Although I understand, Ms. Sierra, regarding the child support, if you're asking for medical support, there's not a difference to me. If he can't pay the medical support, he's not gonna be able to pay the child support, but child support still has to be set at minimum wage. So it's
Yeah.
gonna be set at minimum wage.
Yes,
And
ma'am.
the rest of, I'll approve the rest of the terms that you have testified to on the record. And I pronounce you divorced. However, you're not legally divorced until I sign your decree. So get with your attorney, sign off on it. Mr. Davis, have her sign off on it and submit it.
Yes, ma'am, we'll get
Thank you,
that.
ma'am.
That's all I have, Judge. May I be excused?
Yes,
Thank you, Judge.
Thank you, ma'am.
thank you. Okay, Mr. Lozano?
Morning, Your Honor. The state's here for the occupational license hearings against Herbert Zelaya and Epifanio Barra.
What number is that?
Your Honor, that is number 19, 18 and 19 on your docket.
Okay. And are you announcing that y'all are moving forward on, is Mr. Zelaya present?
No, Your Honor, I'm not seeing Mr. Zelaya present on today's docket.
Okay. And what about the second one?
I'm not
Mr. Barra.
seeing Mr. Barra either, Your Honor.
Okay. So then what is your announcement on this? They haven't come in the last two settings. Well, on Mr. Zelaya on CL 21-2732-I, he hasn't appeared in the last two settings. So that's going to be set on the drop docket.
Yes, Your Honor.
It's already the third one. Okay. And then on Mr. Barra, is this the first time that we've had him before us?
Your Honor, I'm seeing that there was an occupational license hearing on November 8th.
Okay, and then we reset it for today?
That's correct, Your Honor.
Okay, so he hasn't appeared also the second time, so it's the same.
Good morning, Judge. I'm with the law office of Oscar Alvarez. He's actually here in the office right now.
Okay,
Good morning.
Let me go get Mr. Alvarez, Judge.
oh, he appeared the last time and then you all didn't have the paperwork or something had happened.
Judge, if I'm not mistaken, the state had not been notified at the last time and they were reset to today.
Mhm.
Hello, good morning.
Yes, good morning. We're on CL 21-3580-I.
Oscar Alvarez, Your Honor. For
Okay.
Mr. Perez Barra. This is an application for a petition for an occupational driver's license that we had a hearing on the last time. The DA announced that they hadn't reviewed the case or it wasn't set in their docket. They were going to reach out to me before this hearing and they did not do that. So I do not know at this point whether they object or do not object to the petition going forward.
Okay, Mr. Lozano, did you have an opportunity to review the proposed order?
Yes, Your Honor, I did. And then our announcement is going to be that the petitioner needs to amend their order to include proof of an interlock device, ignition interlock device, because the petitioner is asking for time restrictions to be waived. This is required by statute according to Texas Transportation Code 521.248D.
Okay, so Mr. Alvarez, in the case where he wants to travel freely and doesn't
Yes,
have any time restrictions, he'll need to install an ignition interlock.
I can include that in the order, Your Honor.
Okay, so go ahead and prove up your petition. Let me swear your client in.
Sure, Your Honor.
All right, do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, Mr. Alvarez, go ahead.
Your name is Epifanio Perez Barra, is that right?
that's right.
And you're a resident of Hidalgo County and you live at 877 Erling Road in Donna, Texas.
Yes, that's true.
Your Texas driver's license is 405-325-17.
Yes,
Can you give the court the last four numbers of your social security number?
5381.
Okay. Now, your driver's license was suspended by administrative law judge Melissa Ricard on October the 13th, 2021. Is that right?
That's right.
Your suspension was for at least 60 days. Is that correct?
Correct.
Do you have an essential need? In other words, do you really need your license in order to perform your occupation or trade?
Yes, I need to work.
Well, I know you need to work,
Yeah.
but is it necessary
Oh,
for
yes,
you to have a
necessary.
driver's license in order to do your work?
Yes.
Okay. Where is it that you work?
In a refinery and scaffold building.
You need to speak clear and louder for the court.
In a refinery, as a scaffold builder.
You're a scaffold builder in a
Yes.
refinery and you're working out of the state of Louisiana, is that right?
Yes, sir.
Is there a place in Louisiana? What is this? What is the city in Louisiana or the county where you work?
I think it's Calcasieu, Cameron.
Calcasieu County and Cameron County in Louisiana. So they're parishes, is that right?
Yes.
They're not counties. So in order for you to travel from your home here in Donna to Louisiana, you have to travel through various counties. Is that right?
That's right.
That would be Hidalgo County, Wilson County, Kennedy County, Cleburne County, San Patricio County, Refugio County, Victoria County, Wharton County, Fort Bend County, Harris, Liberty County, Beaumont County, and Orange County. Orange County is the last county before you enter the state of Louisiana. Is that right?
That's right.
And then you enter the parishes, the Louisiana parishes where you work as well. Is that right? You asking the court to approve your petition for an occupational driver's license and allow you to drive through every road through those counties in order to get from one location to another in the performance of your job.
Yes, sir.
And you're asking the court to waive the 4-hour restriction and allow you the right to operate a motor vehicle for a period to exceed not more than 12 hours in any 24-hour consecutive hours. Is that right?
That's right.
You have no prior conviction. You have not been convicted of any DWI or alcohol-related case or a drug-related in the last 5 years. Is that right?
That's right.
And you have you comply with the requirement of having a insurance on your vehicle. Is that right? And you provided an SR-22 to the court. Is that correct?
That's correct.
And you're asking the court to allow you to have that occupational driver's license for at least a year, not knowing what the DPS is going to do finally on how much time you're going to be suspended. Is that right?
That's right.
But you anticipate it'll be between 60 days and 1 year. Is that right?
That's right.
Your days of travel will be from 7 a.m. to 7 p.m.
Correct.
You understand that this license is only good for the purposes of occupation and not for recreation or leisure. You understand that? Is that right? Now, the court has instructed you as part of any approval of your petition that you install a guardian interlock. Do you know what that is? It is a device in your vehicle to monitor whether or not you're drinking on the road.
Okay.
And would you
I'm
be able
sorry,
to do
Mr.
that?
Alvarez, hold on. Mr. Barra, I'm sorry. You need to speak up and you need to let your attorney finish what he's saying because you're mumbling and because he's right next to you, but my court reporter is not right next to you.
Okay.
And she needs to be able to hear you or else we will not have a clear record. So please speak up to the camera. Don't be looking at your attorney because then your voice is gonna go that way.
Okay, I got it.
All right. Okay, Mr. Alvarez, go ahead.
So you understand that the court has indicated in the district attorney, the only way they will not contest your application is that you need to install a guardian interlock in your vehicle. Do you understand that?
Yes, I understand.
And you have to submit proof of that to the court. How long do you want that done to be within how many days?
$48 hours. It's always 48 hours in my court as soon as the order is signed.
48 hours. You'll be required to submit proof of installation of the guardian interlock within 48 hours of the signing of this order. Do you understand that?
I understand that.
Okay. That's all I have, Your Honor.
Okay, Mr. Lozano, do you have any questions of the applicant?
Well, yes, Your Honor, just some brief questions.
Go ahead.
Why was your license suspended?
They stopped me like driving intoxicated.
Okay. And have you ever been arrested or convicted of a DWI?
Before, no.
Was there an accident involved?
No.
Did you provide a breath sample?
Yes, sir.
Do you know the result of the breath sample?
The results, I'm not.
I believe it was 0.19.
And when was this DWI?
On April the 2nd. Yes,
Of what year?
2020.
21.
I mean, 21 here.
Is it still pending or did you plead guilty?
No.
Can I explain that? He has not pled guilty. He has a contract with the Cleveland County District Attorney's Office he didn't appear before the court. He's got a contract with Cleveland County on an alternative resolution here, pretrial diversion.
Excuse me, what county was that?
Cleveland County.
Cleveland County. Your Honor, at this time, state does have an objection to the occupational license being granted.
On what grounds?
On the grounds that he has a DWI pending, the defendant is asking that the time restriction be waived.
Okay.
And the DWI is currently pending.
Judge, the statute provides only that he be convicted. Even if he's been convicted, he can apply for an occupation. Here, he has resolved this case through a pretrial diversion. He has not pled guilty. He did not even admit his guilt before the judge. It was simply a contract with the DA's office. And of course, if he violates the provisions of that contract, then it will be placed on the docket. But he does qualify. It doesn't make him ineligible for an occupational driver's license. There's an essential need.
Okay, so I'm gonna grant his occupational driver's license on the grounds, provided that you amend that order. He's to obtain an ignition interlock device within 48 business hours. And submit proof by e-filing that with the court. And then I'll sign the amended order as soon as it's submitted.
Thank you, Your Honor. That's all we have.
Okay, you may be excused.
Thank you.
Okay, thank you. Thank you, Mr. Lozano.
Thank you, Your Honor.
Okay, Ms. Oriana?
Good morning, Your Honor. I have number 33 on your civil docket this morning.
CO 1945889-I, Carmen Estrada Vieira et al. Versus TNT Crane and Rigging et al.
Your Honor, I'm not sure. I don't see opposing counsel connected, either one.
I'm here, Your Honor. It's Brian
Oh.
Richardson for TNT Crane.
There you go. On this one, Your Honor, we had mediation last week and it was settled.
Congratulations.
Thank you.
I feel like I need to pop one of those confetti things each time y'all say that. Okay, how much time do you need to submit all your documents?
Probably 30, 40, 45 days, Your Honor.
Okay. I'm just gonna set a tickler for the 17th before we break for the holidays to see if it's been submitted. So it's just for myself. It's a tickler for myself.
Okay, Judge.
All right. Anything else?
I have nothing further, Your Honor. May I be excused?
Yes, Ms. Richardson?
Thank you.
Same as well. Maybe excuse, nothing further.
Yes, thank you.
Thank you, Your Honor.
Okay, Mr. Moore?
Good morning, Your Honor.
Good morning, sir.
Number 20 on your docket, it's Ricardo Reynosa versus Premier Pools. My opposing counsel, Mike Truesdale, is on, and it's just a short status conference, Your Honor.
Okay, CL 173187-I, and what is the announcement, counselors?
We're just reporting to the court, and we just need to get this matter set for a DCC at some point, Your Honor. We're moving the case forward.
Okay. Well, we're starting to set trials for that. Ms. Castaneda, can you please give me a date for a DCC in January? Ms. Castaneda, oh, sorry.
I'm sorry, Judge. Ms. Lisa's yelling at me that I was muted.
Yes, what is the date?
January 28th at 3:30.
Okay.
Thank you, Your Honor. We have no further business.
Your Honor, I have a quick question. I don't understand what was set for January 28th at 3:30.
Docket control conference so that we can give you your trial setting.
Okay, well, thank you very much. Thank you.
Okay.
Thank you, Judge.
All right. Thank you. Y'all have a good day.
You too, Your Honor. Thank you.
Thank you. Okay, Mr. Benz? You're on mute, Mr. Benz.
I apologize, Your Honor. Good morning, Your Honor. I'm here on number 7, number 9, number 12, and number 13.
Okay, CL 211413-I, Discover Bank versus William Easterly. Is William Easterly present? Okay, William Easterly. William Easterly. William Easterly. Okay, go ahead.
Your Honor, procedurally, we're set for plaintiff's motion for summary judgment. Your Honor, this is a case in which credit was extended by the plaintiff to the defendant. Defendant utilized such credit at the time to pay came due. Payment was not made. Demand was made. Demand was not met. Defendant was in fact served pursuant to the Texas Rules of Civil Procedure. Some type of answer or appearance occurred. Consequently, my client filed a motion for summary judgment. There is no genuine issue of material fact as previously identified. Further, there's no response to the motion for summary judgment. My client's entitled to a final judgment, Your Honor.
And what is the amount of the judgment that your client is requesting?
$10,929.77 post-judgment at a rate of 5% per annum and cost of court, Your Honor, of $470.15.
Okay, and is there order on file to that effect?
If there hasn't, Your Honor, I'll make that clear to my client. It needs to be filed by the end of the day.
Okay, then the court will take judicial notice of all the documents in the court's file. And specifically that the defendant's name was called out 3 times and he did not respond. And the court will grant the relief as requested and put on the record. Okay. And their next case, CL 211423-I, Discover Bank versus Nidia Guerra. Nidia Guerra. Nidia Guerra. Nidia Guerra. Okay, you may proceed.
Your Honor, this is a case in which credit was extended by the plaintiff to the defendant. Defendant utilized such credit. Time to pay came due. Payment was not made. Demand was made. Demand was not met. Defendant was in fact served pursuant to the Texas rules of civil procedure. Some type of appearance or answer was filed. Consequently, my client filed a motion for summary judgment. There is no response to this motion for summary judgment. There's no genuine issue of material fact, as the documents effectively prove up plaintiff's claims against defendants. We're simply asking for a final judgment against the defendant.
In what amount?
$9,984.26 post-judgment at a rate of 5% per annum until the judgment is satisfied, and cost of court of $370.15, Your Honor.
Okay, the court will take judicial notice of the documents in the court's file, specifically that the defendant's name was called out 3 times and no response. And the court will grant, the court is granting the relief requested and put on the record. And is there an order on file for this one?
If there's not one filed, Your Honor, I'll ensure that my client files it before the end of the day.
Okay. And then your next case is CL 21-2266-I Discover Bank versus Oscar Hernandez. Oscar Hernandez. Oscar Hernandez. Oscar Hernandez. Okay, go on.
Your Honor, this is a case in which credit was extended by the plaintiff to the defendant. Defendant utilized such credit. Time to pay came due. Payment was not made. Demand was made. Demand was not met. Defendant wasn't in fact served pursuant to Texas rules of civil procedure. There is no answer on file. There's matters ripe for a default judgment. My client seeking recovery in the amount of $5,215.04. Post-judgment interest at a rate of 5% per annum until the judgment is satisfied, and cost of court of $370.15, Your Honor.
Okay, the court will take judicial notice of the documents in the court's file, specifically that the defendant did not file an answer. Defendant did not appear today after his name was called out 3 times, and the court is granting the relief as requested on the record. Okay, and you said you're also number 13?
That's correct, Your Honor.
Okay, CL 21-2368-I, Discover Bank versus Jorge Medrano Jr. Jorge Medrano Jr. Jorge Medrano Jr. Okay, go ahead.
Your Honor, this is a case in which credit was extended by the plaintiff to the defendant. Defendant utilized such credit at the time to pay came due. Payment was not made. Demand was met. Demand was made. Demand was not met. Defendant was in fact served pursuant to the Texas rules of civil procedure. There is no answer on file. My client is seeking a judgment in the amount of $5,710.63, 5% per annum in post-judgment interest until the judgment is satisfied, and cost of court of $370.15, Your Honor.
Okay, the court will take judicial notice of the documents in the court's file, specifically that no response, no answer was filed by Mr. Medrano. Mr. Medrano also failed to appear today, and is granting the relief as requested.
Your Honor, that concludes my business for this honorable court. I appreciate the court taking these matters up. May I be excused?
Yes, you may.
Thank you, Judge.
Thank you. Okay, Andrea Vela. Attorney Andrea Vela.
Good morning, Your Honor. I'm here on number 32 on your docket, and Juan Gonzalez is opposing counsel. He's here as well.
CL 21-1043-I, Maria Flores Garcia et al. Versus State Farm.
We are just here for a status hearing this morning. We have completed written discovery and taken depositions, and we're scheduled for mediation on December 20th.
Who are you all mediating with?
Alfred Denham.
Okay, come back on January the 26th at 9:30 so we can see how that went.
Okay, sounds good. Thank you, Your Honor.
Go ahead.
Is it possible to get a docket control conference?
Well, I'm gonna see how it went for your mediation first. You'll only need a DCC if you didn't settle. Are you
Correct.
saying you're not gonna settle?
No, I was just saying to avoid if another hearing down the line, if it does settle, we can just submit the
No.
paperwork.
That's okay. I don't mind seeing you all more often.
Okay, Judge, January
All right.
26th.
January the 26th at 9:30.
All right, thank you, Judge.
All right, thank you. Mr. Sabo.
Good morning, Judge. I've got number 30 on the docket with David Solis. We've been texting, so I know he's here, but I don't see him.
I'm here, Your Honor. I'm in the middle of a mediation, but I am now ready to proceed.
You both are multitasking this morning. Mr. Sabo was in another hearing and you all seem to make it here. I appreciate that. All right, CL 21-3034-I, Homero Jose Alcocer Jr. versus Aramares, ADAMARIS, Salinas et al. And what is the announcement?
Judge, this is a status conference. This is a pretty new case. The answer was filed at the end of September. So we're looking at, like, this is a 2-month-old case.
Okay.
Right. The only thing we've done, Your Honor, is exchange initial disclosures. I know we're pending, both sides are pending responses to written discovery, depositions, and mediation, unless it gets resolved before that. But right now, the only work we've done on this is the initial disclosures.
Okay, then I'll give you all some time to work it up. And then, let's see,
Should we get a DCC or just another status?
another status.
Okay.
We'll come back on March the 23rd. I'll give you all plenty of time, about 90 days to see how far you can work it up.
Okay.
9:30.
At 9:30, yes.
Perfect.
Okay.
I have one other case. I don't know if Mr. Sabo does, Your Honor.
I don't. I'm done if the judge will excuse me.
Yes, sir. You have a good day.
Thank you, you too. Bye-bye.
Okay,
The
which
other-
other case?
Number 28 on the court's docket, Your Honor. It's actually 2 hearings today. One of them is a partial motion for summary judgment and then also a status hearing. I've been conversing with Mr. Ray via email while the case was proceeding. With regard to the MSJ, he has no objection, although he did call to my attention that, well, I guess let Mr. Ray make an announcement.
Okay, hold on. Let me call CL 20-2815-I, Daisy Reina et al. Versus Antonio Quintanilla, and the attorneys for the announcement.
Good morning, Your Honor. Barry Ray here for State Farm.
David Solis. On
Sorry.
behalf of the plaintiff.
Good morning, Judge. Good morning, Judge. Rogelio Garcia for defendant Antonio Quintanilla.
Okay.
Oh, that's right. And we have Miss Richardson. I don't know if she is on, but she's the ad litem who's been appointed on this case.
Ms. Garcia Perez is here on her behalf.
Okay.
I apologize, Your Honor. I didn't hear the call. I'm not familiar with the title of the case. Yes, I'm here.
Okay, that's fine. Okay, no problem. And what is the announcement on this?
For the motion for summary judgment, Your Honor, I've conferred with Mr. Ray. He has no objection. He has reviewed my order that has been filed with the court, and the only thing he called to my attention was a misspelling. But he has no objection to the substance of the order, and as such, we're requesting that it be signed.
Okay. And then
That's correct.
All
I'm
right,
sorry.
and the status?
The status is we've done discovery. We are set for mediation on January 21st, 2022. And that's where we are with regards to this case.
And who are y'all mediating with?
Alfred Denham, Your Honor.
Okay. And Ms. Garcia Perez, did Ms. Richardson give you a report to give to the court?
No, Your Honor, the only information that I got was that this was a status hearing and that she was waiting on some more information to be able to reach out and discuss all of the possibilities with the client and the parent, Your Honor.
Okay.
That's correct, Your Honor. We can't provide Ms. Richardson the breakdown and how the funds are going to be dispersed because of the underlying or because of the UIM case that is also before the court.
Okay.
That's the holdup.
And Mr. Solis, you're gonna file an amended order? Or
I
did
can
you
file
already
an-
file it?
I have not filed it. I need to change the spelling of partial. I will get that filed today.
Okay. All right, no, not a problem. Then just
and
simply
Your Honor-
that amended order. Go ahead.
Your Honor, yes, Rogelio Garcia, and if the court recalls, we had considered moving forward with a minor prove-up, but then decided that if they were going to move towards mediation, we would have one hearing and have Ms. Richardson go through the entire file concerning medical records for the minor, and that way we would conserve and have a judicial type of judicial economy for the court and have one hearing instead of two.
Okay. Well, I mean, I think,
Concerning the minor.
okay, so then what do you all want to do then with respect to that? Miss Richardson right now is on medical leave. So she's not gonna be able to, I don't know when she's gonna come back. She has a complicated medical situation right now. And so I think first you all need to find out what her timeline to return back to the office is. And she's requesting that extra information or that information. And Mr. Solis already said he's gonna get her a breakdown. So we need to give her some time to come back as well. But why don't you all talk about that before we move forward with any other scheduling?
Your Honor, I need to confer with Ms. Richardson, but if there's no pressing reason to enter the judgment for the minor, I don't know whether there's a pressing financial need, because I'm not as familiar with the case, but if there's no pressing reason to enter the judgment on the minor, then I wouldn't see a problem with waiting till after mediation, as they suggested, to allow Ms. Richardson to heal a little bit longer. I will double check with her office and see whether there was any pressing financial need to release any funds to this minor to have it done before then, but I haven't been told there was.
Okay.
Well, Your Honor, in light of the fact that this matter is now going to mediation in January, that gives Ms. Richardson a couple of months, 2.5 months, to recover from the medical issue that she's undergoing. But then thereafter, we still would have to get the recommendation to her and the settlement breakdown that Mr. Solis is going to be providing, resolution of the entire matter with her to have that one minor prove-up hearing and have either Ms. Richardson or someone the court would appoint to be able to prove it up for the court.
Okay, you broke up for half of what you said. You froze. Your screen is frozen right
And I
now.
apologize.
It's okay. Look, I'm gonna give y'all some time to I'm gonna wait for the order for Mr. Solis to go ahead and submit, and then I'll sign off on that. We're gonna come back on February the 16th at 9:30. And then we're gonna see how far, where Ms. Richardson has been able to catch up on this case. And then I'll give y'all an opportunity to discuss whether or not it's pressing enough for us to move forward, okay?
Okay. And Your Honor, just for the record, Barry Ray for State Farm, and I agree with Mr. Solis with his motion and the order. I have reviewed it. So I'm agreeing with his partial motion for summary judgment.
Okay, thank you. All right, anything else on this?
I have nothing further with regards to this case or anything else, Your Honor, if I may be excused.
Yes, you may.
Same announcement.
Okay.
Same, Your Honor.
Thank you, Judge.
Thank you, Judge.
All right, y'all have a good day.
Thank you, Your Honor. Thank you.
Thank you. Okay, Mr. McGuire?
Yes, Your Honor, number 11.
CL 210791-I Ford Motor Credit versus Juan Hernandez et al.
Correct, Your Honor. This is a motion for default judgment.
Okay, Juana Hernandez.
Yes, I'm present.
Okay, so Juana Hernandez is present. Mr. McGuire?
Yes. May I have time with her in a waiting room? We might be able to
Yes.
discuss resolving this. Thank you very much.
Okay, you're gonna see an invitation on your screen, Ms. Hernandez, to go into a breakout room, okay?
Okay.
So I need for you to accept that. And then you're gonna discuss with Mr. McGuire how possibly we can resolve this matter, okay?
Okay.
All right, you should see it on your screen now.
Thank you.
Okay. All right, Ms. Sines Martinez?
Good morning, Judge. We are number 29 on the docket. It's CL 195189. And it's Jake Ryan Espinosa versus Marcus Alberto Rodriguez. Mr. Murphy is on behalf of Mr. Espinosa.
Yes, good morning, Your Honor.
Good morning. Okay, and what is the announcement?
Judge, we're here for a status conference. The parties have mediated the case back in August of 2021 with Alfred Denham. We were unsuccessful in reaching a settlement. We just need a docket control conference to set this matter for trial.
Okay, Ms. Castaneda, can you please give me a DCC date?
Sorry, apologies. We could do the January 28th at 4 o'clock.
Okay, January 28th at 4 p.m. for a DCC.
Thank you, Your Honor. I have nothing further before the court. May I be excused?
Yes, ma'am. You certainly may.
Nothing further, Your Honor. May I be excused?
Yes, sir.
Thank you.
Thank you. Mr. Wilson? You're on mute, Mr. Wilson.
Good morning, Your Honor.
Good morning, sir.
On this, I'm sorry, but I just had a problem with my system and I've had to go in and out of all of my documents.
Okay, are you here on
And-
Color Source versus Heriberto Perez?
Yes, Your Honor, that's my
Okay.
case.
CL 21-2497-I, Color Source versus Heriberto Perez, DBA United Truck Collision.
Judge, in this case, the debtor was served on July 21 of 2021. And the return of service was filed on August 19th of 2021. And so this is, and then this matter has been on, motion has been on file for more than 10 days. So we're asking the court to proceed. Judge, I filed, and it may not be in the court's queue yet, but I filed 5 exhibits for this case. Exhibit 1 is the return of citation showing proof of service. Exhibit 2 is the certificate of last known address, which was filed quite some time ago, back in, I believe, September. Exhibit 3 is the affidavit regarding military service, which has documentation which shows that the defendant is not in the military and hasn't been in the military in any recent time point. And Exhibit 4 is the substance of the evidence in support of the pleadings, in which it shows that there was services in form of paint that was provided to the defendant for a period of almost 4 months. He made some payments on the account, but he left a balance of $13,478.72. And this is proved up by both the business records that support this and the other evidence that support the business records being of good quality are supported by the president of Color Source Inc., Kim Wiggins, in her affidavit. I also filed an affidavit, Exhibit 5, regarding attorney's fees. Judge, I would ask that Exhibits 1 through 5 be admitted into evidence.
Okay, I don't see them as exhibits that it's come in yet, but I do see them and I reviewed them. Then you filed each of those on their filing dates, which was August 20th, 2021 and September 30th, 2021. So the court will admit those as evidence.
Your Honor, I'm asking the court to enter the judgment that was prepared on and filed on September 30th of 2021, entitled Default Judgment. Therein, it asked for the principal to be awarded, the interest, attorney's fees, court costs, and post-judgment interest at statutory rate.
And that's the principal amount in the amount of $13,478.72.
Yes, Your Honor.
Okay. The court is granting the default judgment in favor of the plaintiff in the amount as put on the record, and asking for the default judgment order that you filed on September 30th, 2021 to be forwarded to my queue, and I'll sign off on it.
Thank you, Your Honor. That concludes my business. May I be excused?
Yes, sir, you may.
Have a good day, Judge.
Thank you, you too. Okay, Mr. Moreno, what do you have?
Good morning, Your Honor. Number 26 on your docket.
CL 15-1106-I, Lord and Gonzalez versus Ignacio Perez et al.
Yes, ma'am. This matter was supposed to have a DCC, but we recently had service on the second defendant, Your Honor, and she asked for more time. In fact, she's present at this proceeding.
Okay, Elsa Perkle.
Good morning, Your Honor. Yes, ma'am.
Good morning. Okay, so you are going to retain counsel, or are you representing yourself?
No, ma'am. I am. I've been unable to retain counsel at this time, so I would like some more time to retain counsel, please.
Okay, and the last time Mr. Perez showed up, but I don't see Mr. Perez.
Yes. So, my father's
I?
obtained. Oh, go ahead.
Yes, ma'am. Mr. Godinez has filed an entry of appearance on behalf of Mr. Perez today, this morning. He's not present in the hearing.
Okay, I'm sorry. Who entered an appearance?
Godinez, Rick Godinez.
Rick Godinez? Okay. Okay. Then I'll give you an opportunity to be able to speak to Mr. Godinez and to Ms. Perkle's new counsel. I'm going to have you all come back on January the 26th at 9:30. Ms. Perkle, if you don't have an attorney by then, we're going to have to proceed, okay?
Yes, ma'am.
All right. Anything else?
No, ma'am.
All right. Then you all have a good day.
Thank you, Your Honor.
Thank you. Okay, Ms. Teal?
Yes, Judge, I'm here for Capital One Bank. I am number 1 on your docket.
All right, CL 20-1343-I, Capital One Bank versus Noé Olivares. Noé Olivares. All right, go ahead. You're on my DWAP docket.
Yes, Judge, this was set for the DWAP, and our office did file a motion for default judgment on or about January 27th of 2021 because defendant has failed to file an answer in this case.
Okay, so then are you going to be filing an order resetting hearing on that motion?
Yes, Judge, or if you want it, we can do that if you would like.
Just file an order resetting hearing. Make sure that you send it to the last known address of the defendant, and then we'll set you and we'll hear you on that motion.
Okay, thank you, Judge.
Okay, thank you. You have a good day.
Permission to be excused, Judge.
Yes, ma'am. Have a good one.
You too.
Okay, hold on real quick. Who is this on iPhone? The lady with the light colored blouse in your car with sunglasses? You need to remove your sunglasses. Thank you. All right, Miss Thaddeus?
Yes, good morning, Judge. I'm here on number 23 on your docket.
CL 174898-I, Martha Salinas versus Santiago de Leon. Go ahead.
Yes, Your Honor, I'm appearing for both myself and Mr. Bustos. We're here on a status hearing. We have plaintiff's deposition set for December 21st. I would ask the court to give us a status in January, just in case plaintiff does not appear for this deposition.
Okay, January 31st at 9:30.
Thank you, Your Honor. May I be excused?
Yes, ma'am. Thank you. Ms. Trevino. Good morning, ma'am.
Good morning, Your Honor. I have 3 cases this morning, Your Honor. I have number 14, number 22, and number 27. And I'd like to start with number 27.
Sure. F 5377-18-9 in the interest of a minor child. And I did see Mr. Espinosa on. I don't know about Mr. Cavazos.
Good morning, Judge.
Good morning. Mr. Cavazos, can you hear us?
This is Peter Espinosa for Rosita Estrada.
Okay, and I see Mr. Cavazos' screen, but I do not see Mr. Cavazos on. Mr. Espinosa, do you want to contact him and see if he can hear us?
Yeah, let me send him a text because we've been communicating.
Okay.
Let me just say we're on court. So he basically, you know, we have an agreement, but he said he was going to log on.
Okay. I'm going to wait for him and let me see. Ms. Teal, did you remember something else?
No, Judge, at the end, I thought that you had said, hold on. And I thought when I had ended the Zoom setting that you had said something and you needed to speak to me about something.
No, it was, I didn't, but.
Okay.
It'll just, but I'm gonna, now that you came back on, I reminded myself that I'm gonna set a tickler. That order resetting hearing needs to be submitted at least by December the 3rd, okay?
Okay, thank you, Judge.
Yes, ma'am. All right. Oh, there
Your
you are,
Honor.
Mr. Cavazos. Can you hear me?
Yes,
Yeah,
Judge, I
yeah.
apologize. I was in a different hearing. I was I was getting text. I was trying to get off the other hearing.
That's okay. All right. Okay, and what is the announcement on this case?
Here's my understanding. I don't know if Mr. Espinosa, there he is. My understanding is we do have an agreement, Judge. We have an agreement for visitation and for child support between the couple as far as the modification.
Okay, and is that a final order or is that a temporary order?
We are agreeing on the final order, Your Honor. The couple, it's going to be 50-50 for visitation. We were going over the holiday schedules because of the fact that 50-50. So we had agreed that it was going to be 50-50 visitation. Mom gets the odd weeks, dad gets the even weeks, and then we were going to follow the standard possession for holidays except for summer. And,
That's correct, Judge, so far.
I believe it was except for summer and spring break. I don't know if we talked about spring break.
Do you all have your clients on?
Yes.
Yeah, Mr. Pettis should be on.
Okay, and what Mario Perez is your client?
Yes, Your Honor.
And Mr. Espinosa's client is who?
Rosita Estrada, and she's on.
And are they both English speaking?
Yes.
All right. Well, since we have Ms. Trevino here and we have them here and you're ready to do an agreement on the record, I'm going to swear them in and you all can decide who is. Mr. Espinosa, do you want to prove it up with Ms. Estrada?
And I can, Judge, but just in all fairness to the Attorney General, we did not include her in the communication this morning. So.
Oh. Ms. Trevino's like, what's new? Right?
Happens all the time.
All right. So what would you all want to do then? Because I want to make sure you have something in writing. Do you want me to give you an opportunity to talk to Ms. Trevino and then you come back? Because if it's for final, I do need that agreement to be put on the record because it involves minor children. I can give you a quick, I can let you all talk in another room, or do you want to come back? I don't know.
Judge, if we're able to, we're fine. No objections, I guess, to meeting in a breakout room. I don't know about Mr. Espinosa if he has the time.
I'm available, Judge, and whenever Mr. Trevino's available, I'm good.
Okay.
I'm available, Judge.
All right, let me go ahead and assign you to the breakout room.
Thank you, Judge. We'll be right back.
Mr. McLaughlin?
Yes, Your Honor.
Okay, what case?
I'm here on Velocity Investments as assignee of Lending Club versus Jorge and Carla Peña.
Okay, do you know, all right, that's CL 210230-I. I do see the Peña's on, and I do have a notation that a notice of non-suit was filed.
I'm not familiar with the non-suit being filed.
Okay, let me just let me double check that I didn't get misinformation. Hold on.
Excuse me, Judge.
Yes, sir.
This is Mario Perez. Was I supposed to go to some breakout room?
No, the attorneys are having a conference.
Thank you.
They'll come back and let you know. If they need you all in a conference room, then I'll put you guys in one.
Gotcha.
All they're doing in that room is just solidifying what you and your ex-wife, or I'm not sure what your relationship is, agreed to.
Thank you.
Yes, so be on standby. Okay, let me double check. Ms. Castañeda, the notice of non-suit that you had stated had been filed this morning. You had, I understood it was on number 25. Did I get the wrong docket number?
24, ma'am.
Oh, 24. That's Mr. Flanagan's. Okay.
Yes, I'm here, Judge.
Okay. I had confused your case and this case. So let me go ahead. Mr. McLaughlin, you are correct. There wasn't one filed. Okay, so Mr. Peña is on.
Yep.
And have you all had an opportunity to talk?
We spoke earlier. I cannot authorize a settlement as low as he wants to go. I would need to go back to the client and see if they're willing to come down further. I would request time to further that pursuit of a settlement, but I would also recommend that we set a bench trial date to encourage everybody to settle.
Well, this is what I'm gonna do is I'm gonna have you all, okay. Either you all are gonna do this informally, or I'm gonna send you to mediation because Mr. Peña has been showing up.
Perfect.
So,
I think mediation is an excellent idea.
okay, then what I'm gonna do is I'll submit an order of referral of mediation. Mr. Peña, what is your email address?
Yes, Your Honor, it's Jorge.Peña, P-E-N-A, 1979@att.net.
Okay, then we'll get an order of referral sent out to both of you. And Mr. McLaughlin, we'll send it to the email that your firm has submitted to us in the past.
Yes, Your Honor.
And then we'll go ahead and get that set for you all.
Thank you, Your Honor.
Okay, if nothing further, you all are excused.
Thank you,
Thank
Your
you so
Honor.
much. Have a good day.
Thank you. You too. Okay, Mr. McGuire?
Yes, Your Honor. I'm back with Ms. Hernandez. We've had an opportunity to discuss the case. We have worked something out. We would like to ask the court for an entry date if possible, perhaps 30 days. Ms. Hernandez, do you have something you'd like to ask the judge?
No, if we don't have to come back to court, that's fine. But I thank her for taking in this matter.
Okay, so Ms. Hernandez, now that Mr. McGuire and you have spoken, he's going to have a paper, it's called the final order, that you're going, the entry of the judgment, right? That
Yes,
you're
ma'am.
going to be agreeing to. So I do need for you to sign off on that if
Yes,
you
ma'am.
agree to the wording. And did you give Mr. McGuire your email address?
Yes, ma'am, I did.
Okay, perfect. And so once you sign off on that for the next hearing, if you want to show up, you can. If you don't want to, you don't have to, because Mr. McGuire will already have your signature. And if he files that entry. So what we'll do is I'm going to give you all some time to circulate that back and forth. And I'm just going to go ahead and set you for a status. of January the 26th at 9:30. But if everything has been submitted by then, Mr. McGuire, do not show up. You don't have to.
Thank you.
Okay?
Thank you, ma'am.
All
Anything
right.
else? There's nothing more for us. Thank you.
All right. Thank you. Thank you, Mrs. Hernandez. You are excused.
Thank you,
Thank
Mr.
you, ma'am.
Hernandez. Have a great day.
You too, thank you.
Okay, Mr. Flanagan, CO 172642-I, Media Hassle versus Valentin Lopez et al. And this is the one that I had the notice of non-suit filed, correct?
That's correct, Your Honor.
Okay,
The
I'm
case
sorry.
is all done now.
All right, thank
Your
you.
Honor,
See,
if
I
I
wish I had to do
Your
that.
Honor, if I may, they did file a notice, but they did not file an order for you to sign, so we need an order.
Technically, Your Honor, under the law, a notice of non-suit is effective immediately upon filing, but if you, in your judgment, do prefer we file an order of non-suit, we'll be happy to do that, but technically it's not required.
No, and I understand. And the only reason we do is because, believe it or not, it might be hard to believe, but things get complicated in the clerk's office. And so sometimes if they don't see order, they will not dispose of it. They won't title it disposed of.
I
So,
understand.
yeah, and I
We'll-
agree
we'll
with you,
file
Mr.
one.
Flanagan. I agree with you, of course, but unfortunately, it's just that extra step that we take because we have found in our 11 months, if we don't, they won't close it.
Yes, Your Honor. I'll take care of that. Thank you. May I be excused?
Yes, sir. Thank you for your patience.
You're welcome. And also, by the way, Mr. Damon Garcia, I was appearing on his behalf as well. He was the remaining defendant's attorney. Okay, thank
Okay.
you.
All right, thank you. Have a good day, sir. Okay, Ms. Maduena. Okay, Ms. Maduena on F 3154-21-9. Ma'am, are you English speaking or Spanish speaking? Okay, can you please press on the microphone at the bottom?
Can you hear me, Your Honor?
I certainly can now. Okay, so are you
Okay.
ready to proceed on your divorce?
Yes, Your Honor.
Let me find that for you.
Okay, thank you.
Oops. Okay, so the court is taking judicial notice of all the documents in the court's files, specifically the waiver of service that was filed by Mr. Maduena, and that was filed on July 7th, 2021. In it, he does state that he does not want the court to enter any orders unless the order is signed by him or he has received written notice of the date, time, and place of the hearing. Let the record reflect that on October the 8th, 2021, the court signed an order setting hearing for today's hearing date, and it was mailed to Mr. Maduena at his last known address. So I'm going to call out his name out 3 times. So Agustin Maduena, Agustin Maduena, Agustin Maduena. Okay. So Mr. Maduena was given notice as per his request on his waiver of service. He has failed to appear today. I do not see that a divorce decree is on file, Ms. Maduena. Were you going to be filing one?
Yes.
Do you and your husband have any children together?
Yes.
Are they
We have 3.
minors?
One minor. He's 14 years old.
What is the name?
Daniel Madueña.
And did you and your husband come up with an agreement with respect to child support, visitation, and medical support?
Yes, Your Honor. Yeah, we came to an agreement already.
Okay. Well, let me go ahead and have you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, ma'am, please state your full name for the record.
Mireida Madueña.
And you filed for divorce from your husband, Agustin Maduena, is that correct?
Yes, Your Honor.
And you had lived in Hidalgo County for at least 90 days and in Texas for at least 6 months when you filed for this divorce?
Yes, Your Honor.
You were married on or about October 25th, 2002 and separated on March 5th, 2021, is that correct?
Yes, Your Honor.
You have one minor child remaining, Daniel Maduena,
Yes, Your Honor.
and he is, you said 14 years old?
Yes, Your Honor.
Okay. And you are asking for a divorce today because your marriage has become insupportable because of discord or conflict that prevents the legitimate ends of your relationship?
Yes, Your Honor.
And you are also asking for you to be named as the primary managing conservator with the exclusive right to determine where your son lives?
Yes, Your Honor.
You're also asking for the exclusive right to apply and renew passports, is that correct?
Correct, Your Honor.
And you're also asking that your husband have standard visitation.
Yes, Your Honor.
And at this time, you are not expecting a child, is that correct?
Correct, Your Honor.
And you do not have another child while you were married to your husband.
Correct, Your Honor.
And there is not a protective order that is in place, is that correct?
Correct, Your Honor.
Okay. And you and your husband do not have any community property, is that correct?
Correct, Your Honor.
And so you will be in charge of any debts that are under your name, and he's going to be in charge of any debts that are under his name, correct?
Correct, Your Honor.
What type of insurance does your son have?
He has Medicaid.
Okay. Because he has Medicaid, your husband is going to be required to pay medical support in the amount of $100 per month. And
Yes, Your Honor.
that goes to the state of Texas.
Oh, yes, Your Honor.
Do you have any wage information on your husband, or have you all agreed to an amount?
Yeah, we agreed to an amount that he was going to give him $100 per month.
Okay, that's too low. The law allows for minimum wage. So he'll be ordered to pay the minimum wage for child support.
Okay, Your Honor.
And also, I'm granting your name change to Mireida Rodriguez.
Okay, thank you, Your Honor. Yes.
Okay, so now you need to do a divorce decree that incorporates everything that I've ordered today, okay?
Your Honor. Yes, thank you.
And you're only gonna have until December the 17th to turn it in.
Okay, Your Honor. Thank you.
So you're not divorced until I sign that paper, okay?
Oh, okay, so you just need the decree, right?
That's
Sign
it.
paper? Okay,
That's it.
Your Honor. I had a question. Where do I bring it? Do I bring it here?
Yes,
Okay.
downstairs where you filed your petition.
Oh, okay. Okay, Your Honor. Okay. Thank you so much.
Okay, you're welcome. You have a good day.
You too. Thank you. Bye-bye.
Thank you.
Okay, bye.
Okay, Mr. Brian Ramirez, are you here on a case?
Yes, good morning, Your Honor. I'm here for number 21 on your docket on behalf of plaintiff Los Venados.
Okay. And who's on the other side?
It is Armando and Susanna Bautista.
No, is anybody representing them?
No, see, that's what we're here about today. We're here to ask the court to grant our motion to appoint the defendants an attorney ad litem so that we can go ahead and serve them by publication.
Oh, okay. So you have you filed your motion for substitution of service?
We filed our motion asking the court to grant us the ability to serve them by publication. We also filed our declarations by one of our attorneys and our server swearing and attesting to our diligent efforts to serve the defendants to no avail.
Okay, so no, I understand, but so y'all filed a motion for service of citation by publication, correct? Back in July.
Yes, ma'am, correct.
Okay, so let me see, motion of citation by publication. Okay, so then the assertion is that they have been unable to locate them because they do not know where they live anymore?
Yes, that's correct.
Okay. All right. So then you're asking for your motion for service of citation by publication to be granted?
Yes, that's correct.
Okay. So then based on the affidavits, based on the exhibits that were filed with your motion for service, which is the declaration of yourself?
One of our attorneys, Rick Zuniga, with our firm, along with our server, I believe he goes by the last name Martinez.
So, okay, you're Brian Ramirez.
Yes, ma'am.
This is Brian
Yes,
Martinez. What
Brian
are the
Martinez,
odds, two
correct.
Brians?
I don't know, and it's spelled with a Y too.
Yeah, that's not very common.
Mhm.
Okay, and then it was Rick Zuniga, which is the civil process.
Yes, I'm here on his behalf today.
Oh, no, he's the other attorney. Okay,
Yes, correct.
got you. All right, so then the court will grant your motion for substitution of service and allow the citation by publication to occur. And then I'm gonna go ahead and also have the other order appointing the attorney ad litem for that publication to occur to be forwarded to my queue. Okay, so I'll have both those orders forwarded to my queue and I'll sign off on them.
Okay, Judge, thank you very much. That
Okay.
concludes my business with the court. May I be excused?
Yes, you may.
Thank you. Have a happy
All right.
Thanksgiving, everybody.
You too. Mr. Wallace?
Yes, Your Honor. Good morning.
Good morning, sir. Do you know what number you are on the court's docket?
Yeah, so I should be number 36 on the court's docket.
Okay, yes, you are. Cash versus Teresa Barcenos.
Yes, Your Honor.
All right, and Teresa Barcenas, are you present? Teresa Barcenas? Teresa Barcenas. Okay, that's on CO 14-3492-I, Cash LLC versus Teresa Barcenas. You may proceed.
Yes, Your Honor. In the matter of Cash LLC versus Teresa Barcenas, the plaintiff would move for final judgment in its favor. They would ask for judgment in the amount of $3,116.10. In addition, they also asked for all court costs, no attorney's fees, and a 5% post-judgment interest rate. This is based on an account, the last four digits 1104, that was opened in September of 2011 with the original creditor, GE Money Bank. After non-payment, the account was charged off in March of 2013. It was then transferred to the current plaintiff through a sale in April of 2013. We have filed with the court an affidavit by the current plaintiff that attests to the original opening of the account with GE Money Bank, the original creditor, the charge-off and sale, the current balance that is still owed on the account, as well as account statements that attest to the account that was opened by the defendant. We ask that the court enter those into evidence and grant a final judgment in the plaintiff's favor.
Okay, the court will admit those into evidence and also grant the relief requested by the plaintiff. Do you have an order to that effect?
Yes, Your Honor. We have filed a final judgment order with the court.
Okay. And I'll ask for that to be forwarded to my queue and I'll sign off on it, sir.
Okay. Thank you very much, Your Honor.
Thank you. You have a good day.
You do as well.
Okay. Mr. Espinosa, Mr. Cavazos, and Ms. Trevino, are you all ready?
Yes, Your Honor.
Yes, Judge.
Okay. So then do we go ahead and swear your clients in?
Yes.
Okay. So Ms. Estrada and Mr. Perez, can you please unmute yourselves? Okay, and raise your right hands. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Estrada? Okay, I can't hear you. You might want to pick up the volume or raise the volume.
Is that better? Can you hear me?
Yes. Okay, Mr. Perez, yes or no?
Yes.
Okay, and who is going to be proving it up?
Judge, I can prove it up.
Okay, go ahead. I think your client froze though.
Ms. Estrada?
Good morning, Your Honor. Jaime Cavazos, Perez. I apologize, Judge.
It's okay. You're freezing, Miss Estrada.
Let me go outside. It's because I was at an interview.
Oh, okay.
Is that better?
Yes, it's just a little windy.
How about now?
Okay, can you state your name for the record?
Rosita Estrada.
Okay. And Ms. Estrada, what I'm going to do is read the agreement that we've reached. And I'll just ask if you're in agreement with it. And then I'll ask Mr. Perez if he's in agreement.
Okay.
Now, at this point, you are currently in primary custody of your child with initials of AJP. Is that correct?
Yes.
And the agreement is that you're going to have primary custody of AJP. Is that correct?
Yes.
And that you will, that between you and Mr. Perez, you will be a joint management conservator with the visitation and custody will be a 50-50, which will be a week to week. And that every Sunday, and every Sunday at 6 p.m. you will be exchanging for a pickup and drop off of your child. Is that your understanding?
Yes.
Okay, and then the pickup and drop off will be at Mr. Perez's parents' house. Is that your understanding?
Yes.
Okay. Now, at any time, if there's a mutual agreement, that you will have the ability to have a mutual agreement as to any kind of different pickup with Mr. Perez. Do you understand that?
Yes.
Okay. As to the holidays, there will be a per the standard possession order of the family court. So that means that you will get every other Christmas and he will get every other Thanksgiving, and you will be exchanging from year to year. Is that your understanding?
Yes.
And there won't be any type of summer possession because you'll be doing a week to week exchange. Is that your understanding?
Yes.
As to the child support, the child support has been agreed that he'll be paying $227 per month starting, is it October 1st, Mr. Cavazos?
I believe that was my understanding, yes.
Okay, as of October 1st, 2021, child support will be starting at $227 a month that will be paid by Mr. Perez to you for child support. Is that your understanding?
Yes.
And then medical support will be paid at $57 a month, and that will be collected through the Office of the Attorney General of Child Support, also starting October 1st, 2021. Is that your understanding?
Yes.
And then there's a back child support owed in the amount of $4,625.31 as of September 28th, 2021. Is that your understanding?
Yes.
And that there will be a payment plan that will be added that Mr. Perez will pay at $75 per month as of starting October 1st, 2021. Is that your understanding?
Yes.
There's also medical support amount that's owed by Mr. Perez of $653.43 as of September 28th, 2021, and that will be paid at $25 per month starting October 1st, 2021. Is that your understanding?
Yes.
And that you will be the primary conservator, that you will have the ability to, the exclusive right to name the residence of your child. Is that your understanding?
Yes.
And that also there will be no geographic restriction. Is that your understanding?
Yes.
And that you will be responsible for making sure that your child is insured, even though Mr. Pettis is paying the medical insurance, you will be responsible to make sure that she's insured for medical insurance. Is that your understanding? Is that a yes?
Yes. Yes.
Now, also, you've asked the court to have a non-disclosure on your file, which basically means that your address, phone number, and personal information will not be part of the public record. Is that your understanding?
Yes.
Is there anything further?
No.
I pass the witness at this time.
Mr. Cavazos, do you have any questions of the witness?
Just one real quick question. On the week to week that the exchange happens on Sunday at 6, is it your understanding that you would get the odd weeks and that's going to get the even weeks?
That's fine with me.
And unless you all agree differently, but that just makes it simpler so that you all don't have. That's all I have, Your Honor.
Okay, so then do you have any questions of your client, Mr. Cavazos?
Just a few.
Okay, Mr. Pettis, please listen carefully.
Mr. Perez, you have heard the testimony of Ms. Estrada. Are you in agreement with all her answers?
Yes.
And is that your understanding of the agreement you have reached with her?
Yes.
And do you feel that this is in the best interest of your child, of your son?
Yes.
And you feel that y'all are able to work out an agreement where she will be able to go to your mom's? And I think that's actually what you're doing right now, right? Is that correct?
Yes.
And you also saw where she has not wanted to make her address public, and you understand that?
Yes, sir.
Okay, and you understand that that the agreement here is not only the best interest of the child, but it's also best for you and mom, right?
Correct.
Okay. Do you have any questions?
No further questions.
Okay, so are you asking the court to approve this agreement?
Yes.
Okay, that's all I have, Your Honor.
Judge?
Go ahead.
Sorry. Judge, if I may, I want to let Ms. Trevino the opportunity to ask any questions.
And that's where I was going next. Okay.
Sorry.
It's okay. Ms. Trevino, did you want to ask them any questions?
Yes, ma'am, to Mrs. Estrada. Mrs. Estrada, what insurance are your children currently enrolled under?
Medicaid.
Okay. And regarding the non-disclosure, are you asking the court to keep your address and telephone number confidential?
The phone number is okay, just not the address.
Just, okay. That's all I have, Your Honor. I pass away.
All right. Then if nothing further, the court is approving the agreement as testified to on the record, and I commend both of you for coming up with an agreement that is in the best interest of your child and for your situation, because you took control and you're doing what's best for you also. I do commend that. So make sure that the order is circulated and that it's signed off by all the attorneys, including Ms. Trevino and the parties. And so how much time do y'all need for that?
Judge, we need about 21 days. I think we can get it done within that time.
Okay. Let's see, I'm gonna put a tickler for December the 17th and just make sure that it's submitted by that time. Okay? All right, good luck at your interview, Ms. Estrada.
Thank you. I appreciate it.
Okay, you all are all excused.
Thank you, Judge. You all stay safe.
Okay, thank you. Okay, we're gonna continue, but we're taking a 5-minute break. I appreciate your patience. But we've been on for quite a while, and so we do need a 5-minute break. You can turn off your cameras as soon as we come back on. I'll let you know, and your cameras will go back on, okay? We'll be right back.
So that one's down.
From you. I'm sorry about you. Did you say you get back with you about the Zoom? Only because we have the.
I haven't checked. I've been on Zoom all morning.
You've been busy.
Yeah, I should be done. We're just on a 5-minute break, and then I have 2 cases. So.
Okay, no, whatever. You're right. I'm sorry. I didn't mean to bother you.
No problem. Let me check because I sent her an email. Let me check if she answered. No, not yet.
What time were they gonna start at?
I think at 9.
9 for what, 45 minutes each one?
But
or
if
an
you
hour?
don't mind asking her, will I get done here?
Yeah, let me see if I can get in it. Maybe we get it created.
Yeah.
Okay.
Okay, Ms. Flores, are you ready?
Yes, Judge, ready.
Okay. We're back on the record. Ms. Trevino, which other case did you have? I'm sorry.
Yes, Your Honor, I had number 22 and number 14. Number 22 is a status hearing. Number 14 is a hearing.
Okay, number 22 is F4019-20-9 in the matter of the marriage of San Juana Maldonado and Victor Carranza. Is San Juana here or Victor?
Hola, estoy aquí. Buenas tardes. Días.
Ms. Castañeda, can you please translate?
Yes, Your Honor, I'm sorry, I was on the phone with Ms. Thompson's office.
Okay, are you ready?
Yes, ma'am.
Okay, sorry. All right, so let the record reflect that Ms. Maldonado is present and Victor Carranza. Victor Carranza? Okay, ask Ms. Maldonado if she's heard from her husband.
Ms. Maldonado, ¿ha tenido usted noticias de su esposo?
No.
No.
Okay, so what is your announcement, Ms. Trevino?
Your Honor, in this case, the Office of the Attorney General filed an intervention with a motion for confirmation of arrears. We did file an order consolidating the cases. I had noticed in Ms. Maldonado's proposed decree that she was requesting that the previous order continue. So we need the cases consolidated.
Okay, and then, and so that order consolidating the suits, I haven't signed off on that yet, right?
Right.
Okay, so I'll ask for that to be forwarded to my queue, and then I'll sign off on it. Ms. Castañeda, please let Ms. Maldonado know that I'll be signing an order that consolidates the first case she had and this case.
Ms. Maldonado, la juez va a firmar la orden que tiene, donde van a considerar los casos, el primer caso que tenía con este caso.
Muy bien.
Okay.
Okay.
Okay, so now the thing is, so then how much time do we need in order to, she technically has to have you sign off on the divorce decree now.
Okay. I can work with her on that, Your Honor, to ensure that we get the judgment amounts into the order.
Okay, Ms. Castañeda, please tell her that she has to work with Ms. Trevino in order to get the correct judgment amounts on that divorce decree.
Ms. Maldonado, usted va a tener que estar en comunicación con Ms. Trevino para agarrar las cantidades correctas para poner en el decreto.
Muy bien.
That's fine.
Do you have contact information for her, Ms. Trevino?
Yes, Your Honor, and I also have her email address, so I will initiate the communication with her.
Okay, let her know, Ms. Castañeda, that they will be communicating with her either by email or calling her.
Ms. Maldonado, se van a estar comunicando con usted por email o por teléfono.
Okay.
Okay.
All right. Okay, so then let's go ahead and come back on January the 26th at 9:30. Let her know, Ms. Castañeda, that we'll come back on January 26th at 9:30.
Ms. Maldonado, la próxima corte es el 26 de enero a las 9:30 de la mañana.
El 26 de enero es para el child support.
What is it for the child support?
It's to try to finalize her divorce.
Para ver si finalizamos el divorcio.
Hoy no se pudo.
We can't do it today?
No.
No.
¿Por qué?
Why?
Because she doesn't have the correct information on her decree.
Porque no tiene su información correcta en el decreto.
Okay.
Okay.
Necesito regirla para terminarlo el 26?
She's
El
gonna
20
let her know that Ms. Trevino is going to talk to her about that information that she needs to include.
La señora Treviño va a hablar con usted para qué es la información que tienen que incorporar.
Ok.
Okay.
All right, so we'll see her here on January the 26th at 9:30.
So la miramos aquí el 26 de enero a las 9:30.
El 26 de enero, ok.
January 26, okay.
All right, she's excused.
Se puede retirar.
Ok. Gracias.
Okay, and your next case?
The next case, Your Honor, is number 14.
F 3880-06-9 in the interest of a minor child. Okay, and who's supposed to appear on this one? Do you know?
I had seen a Tanya Mesa, and I'm not sure if that was the CP in this case.
Tanya Mesa, can you hear me?
Yes,
Okay, ma'am.
I think
And-
I'm on now.
All right, and Miss Mesa, are you the mother of Serenity Laura Lee Martinez?
Yes,
And is it just one child?
yes,
Okay, and you're the custodial parent?
correct.
Okay, and who is the father?
George Anthony Martinez.
Okay, and I do not see a George Anthony Martinez present. Okay, and is this so this is your motion, Ms. Trevino?
Yes, it is, Your Honor. And the office had filed a motion for modification and confirmation of arrears. Excuse me. And we're present to go, Your Honor. We do have a request for non-disclosure also.
Okay.
And at this time, I'd like to ask the court to take judicial notice of all pleadings and records and exhibits on file.
Okay, the court is taking judicial notice of all the records and pleadings in the court's file.
And Mr. Martinez, Your Honor, was served by personal service on June 20th, 2020.
Okay. And the court will also take notice that Mr. Martinez was served and he failed to file an answer or appear today.
Ms. Rodriguez, do
Yes,
you
ma'am.
have safety concerns with Mr. Martinez knowing your address and telephone number?
Hold on, let me go ahead and swear her in.
Oh, that's right. I'm sorry.
That's okay. Okay, please raise your right hand, Ms. Mesa. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Okay, you may proceed now.
And do you go by Ms. Rodriguez or Ms. Mesa?
Rodriguez is fine. Rodriguez.
Okay. And ma'am, do you have safety concerns with Mr. Martinez knowing your address and telephone number?
Not necessarily. He's had the information and it hasn't changed.
Okay, and if you were to move, would him knowing your address put you or the child at risk of harm, injury, or harassment?
I honestly don't know. I haven't received any harassment from him recently, but he is unpredictable, but I don't know.
And what was the conduct that led you to request a non-disclosure?
He's made statements to my daughter about I think he quit drinking. I don't know if he's going through depression or alcoholism, or he'll just make statements maybe of a welfare type. I don't know how to explain it. Like he's not stable.
Can you tell the court what statements he made?
I would have to ask her. She's in her room.
And from what she
No,
has,
we're not gonna do that. Okay, so it's only on
Okay.
personal knowledge, Ms. Rodriguez. So,
Yeah, then that's fine. If he's aware of my address, that's fine.
well, let me ask you this. Does he know where you live right now?
You're right. That's what I was saying. He's known
Okay.
where we live, and I haven't received any harassment, so I don't see a problem with it.
What I will order, Mr. Trevino, is that if Ms. Rodriguez does move in the future, that address will not be disclosed to Mr. Martinez, since he already knows where she lives now.
Okay. That'll be fine, Your Honor.
Okay, you may proceed.
And Ms. Rodriguez, you have requested that the prior child support order be modified?
Yes, I believe it was in 2019 or 18.
Okay. And do you have any knowledge as to where Mr. Martinez works?
He, last I knew, was Time Warner Cable or Spectrum because of the insurance card that my daughter has, the health insurance.
Okay. And in connection with the child support, following the order that was obtained in this case, did Mr. Martinez make any direct payments to you?
No.
Did you and he live together for any extended periods of time?
No.
And did he have possession of your daughter for periods in excess of the visitation periods?
No.
You're not, in addition, Ms. Rodriguez, you had requested that Mr. Martinez be ordered to reimburse you for some medical expenses that you incurred for the child, that he has not paid his portion of those expenses. Is that correct?
Correct.
And at this time, I'd like to offer into evidence States Exhibit A, the financial activity report, and States Exhibit B, the request for unreimbursed medical expenses.
Okay, Ms. Rodriguez, do you have any objection to those being admitted?
No.
Okay, those will be admitted.
Your Honor, the state is requesting that child support be modified. Child support currently is $310 a month. The state is requesting that it be modified based on information available to the office, Your Honor. In the last 12 months, Mr. Martinez's income has been $60,230.30, which gives us a monthly gross of $5,019.19. The state is requesting child support be modified to $606. Beginning, we're requesting that it be applied retroactively to July 1st, 2021, which is the first month after the date Mr. Martinez was served. And the state is requesting a medical support obligation of, let's see. Oh, he is currently, Your Honor, has the children under his insurance, and he has been given credit for the amount of the premium. He was also given a variance for 2 children not before the court in calculating the child support obligation of $606. And we gave him a credit of $332 on the medical support, Your Honor.
Okay.
The state is also requesting a child support arrears judgment in the amount of $620 as of October 31st, 2021, to be paid at $25 beginning December 1st, 2021, a medical support judgment of $0, and with the child support obligation beginning also beginning on July 1st, 2020.
Okay, and what did you say the new child support amount is? I'm sorry.
It's $606.
Okay.
The state is also requesting, Your Honor, that Mr. Martinez be ordered to pay Ms. Rodriguez the unreimbursed medical expenses in the amount of $1,500 $462.60.
All right. Then the court is granting the relief as testified to on the record. The new child support amount will change to the $606, which satisfies the statute, and also will grant the unreimbursed medical expenses in the amount of $1,462.60, and will confirm the judgment of the arrears in the amount of $620. And that order, how long do you need to submit it, Ms. Trevino?
I should have it within 2 weeks, Judge, probably a lot earlier, but I am going to take a little bit of time off.
Okay. Well deserved, I'm sure. So
thank you.
I'll go ahead and set a tickler for December the 17th.
Okay, that'll be fine, Judge.
Okay. Ms. Rodriguez, best of luck to you, ma'am.
Thank you. Thank
Okay,
you, Judge.
you're excused. Any other case, Ms. Trevino?
That's all I have for today, Your Honor. Thank you.
Okay, thank you. Mr. Quintana, what do you have?
Your Honor, I'm here on number 8 on your docket, Peña versus Gomez. I represent Adriana Peña. Motion for summary judgment.
Okay. And who was going to be coming in for the defense?
Your Honor,
it's Eric Holguin. I'm standing in for Mr. Rick Perez.
Okay. Okay, there you are. All right, so is this going to be contested?
Yes, it is.
Okay, then let me finish up with the docket and I'll take you up shortly.
Thank you, Your Honor.
Okay, Mr. Mendoza, Elodio Mendoza, what case do you have, sir?
Sí.
Okay. Ms. Castaneda, he's Spanish speaking. Ask him is he the one that filed the appeal, or is he the one that had the judgment in favor of him at the JP level?
Mr. Mendoza, ¿usted fue el que metió la petición para la apelación?
Sí.
Yes.
No. Fue, yo lo demandé a él.
No, I sued him.
Okay, so Jorge Martinez.
Sí.
Okay, bueno, tell him that I'm going to call out that name 3 times.
Okay, van a llamar ese nombre 3 veces.
Okay.
Jorge Martinez Jr. Jorge Martinez. Jorge Martinez. Okay, Mr. Martinez is the one that filed the appeal. He is not present in order to perfect his appeal or to ask for it to move forward or prove it up. Therefore, the appeal is denied. The judgment of the lower court stands. Let him know, please.
Mr. Mendoza, la juez llamó al nombre de Mr. Martínez y la apelación es denegada.
¿Y qué sigue? ¿Qué sigue hacer?
What's next to do?
Just let him know that whatever was ordered in the lower court is what's going to happen.
Lo que estaba ordenado en la previa corte, eso es lo que va a pasar.
¿Se va a abrir otra corte o qué?
No.
Is there another court that's going to be open?
Sorry, no.
No.
¿Y cómo me va a pagar el señor?
And how is he going to pay me?
I cannot give him any legal advice as to how he can perfect his judgment. That's something that he's going to have to explore on his own.
Okay, no le podemos dar cómo vaya a hacer usted perfeccionar su juicio. Eso lo tiene que hacer usted solo.
Pero yo necesito que me desocupe él la casa.
But I need for him to leave the house.
Porque yo tengo que pagar mis taxas de la
Because I have
casa.
to pay my taxes.
Let him know that the lower court, the JP, probably gave him an order. So he needs to do whatever he needs with that order. I cannot tell him what to do. My only job was to either hear the appeal and grant it or deny it. And I've already denied it.
Okay, yo no le puedo dar consejos. La previa corte, que fue la primera corte que tuvieron, tuvo que haberle dado una orden. Esa es la orden que se va a seguir. Mi trabajo era de oír esta apelación y ya la escuché y se denegó.
So if he has any questions, he will need to go to the JP court where he filed this lawsuit.
So, si tiene preguntas, va a tener que ir a la previa corte de tribunal y a preguntarles a ellos.
A la primera que fui.
Correcto.
Oh, ok, tengo que ir para atrás a ver qué pasó.
So I have to go back and see what happened.
He should have an order. I cannot tell him anymore. Tell him he's excused.
Usted debe tener una previa orden y ya no le puedo decir nada, ya se puede retirar.
Ok, muchas gracias.
Okay,
Adiós.
thank you.
Bye.
Okay, Ms. Serna, F 4353-21-9 in regard to Flor Estela Serna. Ms. Serna, English speaking or Spanish speaking?
English.
Okay, Ms. Serna, you have made an application for an adult name change. Is that correct?
Yes, ma'am.
And I am in receipt of your criminal history report from the Texas Department of Public Safety. In that report, ma'am, are you the same person that has the offenses that have been listed on there?
Yes, ma'am.
Okay. So were all of these matters disposed of?
Yes, ma'am.
And why are you seeking a name change today?
So when I asked for my divorce, he was incarcerated, and the only way he would give me my divorce was that I kept his last name. And last year, my daughter came out saying that he was sexually abusing her. So we have an open case with the district attorney, I think it's called, here in Edinburgh. And well, I just don't want his last name.
Okay, so are you asking to return to Flor Estela Garcia?
Yes, ma'am.
Okay. Now, are any of these, are you seeking a name change today to escape any criminal prosecution?
No, ma'am.
And it does indicate here on your criminal history report that you have actually also, let me see, gone under other, you've been Flor Estela Serna, Flor Garcia, Flor Estela Garcia, is that correct?
Yes, ma'am.
And who is Jessica Perez Marroquin?
Jessica Perez Marroquin.
Is that name affiliated with you?
I don't recall. I know that all my previous charges were under my maiden name before I ever got married.
Okay, but is Jessica Perez Marroquin a name that you've used in the past?
I think Jessica Perez Marroquin was a name that was given to me after I was arrested when I was like 19.
But what do you mean given to you?
So I was with my sister-in-law and she was caught stealing and I wasn't stealing. So I thought they were gonna release me, and that's the name that we gave.
Oh, okay. This was back in 2004?
Yeah, like 2003 or 2004. And when I got to Hidalgo County that they gave me my charges, I let them know that my name was Flor Estela Garcia.
Okay. All right, then the court will find that that name is already under the Texas Department of Public Safety and Criminal History. So it is a name that you have previously used, and it is a name that is discoverable. So the court will grant your request for a name change. And let me see if your order is correct. Okay. Okay, you are actually now the felonies that you were charged with, were they all on deferred disposition? Or were you actually convicted of some of those felonies?
No, I was convicted. I served 2 years in Florida.
So then it's gonna be that the box that I'm gonna check off, because it's not checked off, is that you have been convicted of a felony and you're changing your name to the primary name used in your criminal history record information, because they originally had you as Flores de la Garcia, okay?
Yes.
All right, so then I'm gonna ask for that order that you filed on September 30th, 2021 to be forwarded to my queue for signature, and then it'll be sent out to you, okay?
Okay, do I need to do anything
No,
at
ma'am.
this point or just wait for the paperwork?
Yes, ma'am, you'll just wait for the paperwork.
I thank you so much.
Okay, thank you, ma'am. You have a good day.
Likewise. Bye-bye.
Okay, Mr. Reyes, what case are you here on?
Yes, Your Honor.
Yes, sir. What case are you here on? On a
Actually,
divorce
don't.
with Yvette
Yes.
Guzman Reyes. Is Yvette Guzman Reyes present?
Yes, I'm here, Your Honor.
Okay, so that's on F 2943-21-9. And have Ms. Reyes and Mr. Reyes, have you all had an opportunity to discuss the terms of your divorce?
Yes.
And have you all entered into an agreement?
Yes.
Okay.
Yes.
All right, hold on. Let me go ahead and bring that up.
Front entry door.
Okay, so you and your husband, you do not have any children together.
Yes, we do.
Are they all over the age of 18?
Yes, they are.
Oh, okay. So we don't have to deal with child support or health insurance or anything like that?
No.
Okay. All right, let me have both of you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Reyes?
Yes.
Mr. Reyes?
Yes, Your Honor.
Okay, you may lower your hands. Ms. Reyes, please state your full name on the record.
Yvette Reyes.
And ma'am, you're currently married to Cirilo Reyes, is that correct?
Yes.
At the time that you filed for divorce, you had been in Hidalgo County for at least 90 days and in Texas for at least 6 months, is that correct?
Yes, ma'am.
And you were married on or about February 25th, 1999, and you were separated on September 20th, 2019, is that correct?
Yes, ma'am.
And you're asking the court for a divorce today because your marriage has become insupportable due to discord or conflict of personalities that destroys the legitimate ends of the marital relationship, is that correct?
Yes, ma'am.
At this time, is there any reasonable expectation of reconciliation?
No, ma'am.
And are you currently expecting a child of this marriage, ma'am?
No, ma'am.
Have you had a child with another man outside of the marriage?
I have not.
Okay. Do you have a protective order against your husband at this time?
No, I don't.
And as far as property is concerned, you and your husband do not have any community property at this time, is that correct?
That's correct.
So you will be paying any debts that are under your name and he will be paying any debts that are under his name, is that correct?
That's correct.
Is there any retirement that needs to be divided? Or are you all keeping your own retirement, or what's happening with the retirement accounts?
He's keeping his retirement.
Okay, and do you have a retirement account?
I don't.
Okay, and it's your agreement that Mr. Reyes is staying with his retirement account?
Yes.
Okay. Is there anything else that, besides your personal effects, that you all will be dividing today?
No, ma'am.
Okay, so do you already have everything divided, such as televisions, furniture, anything of that nature?
Yes.
Okay, and you're also asking for a name change back to your maiden name of Guzman?
Yes, ma'am.
Okay. Is there anything that you and your husband have agreed to that you have not testified to on the record yet?
No.
Okay. Mr. Reyes, you've heard the testimony of your wife today. Is that your understanding of the agreement?
Yes, ma'am.
Okay. And is there anything that you need to put on the record that we didn't cover with your wife?
No, that's about it.
Okay. So you did file a divorce decree. That divorce decree does seem to be correct. So I'm going to ask for that divorce decree to be forwarded to my queue so that I can sign it. And you should be receiving that via email. Ms. Guzman will be receiving it at the email that she provided. Mr. Reyes, do you have an email address?
Yes, ma'am.
What is your email address?
CIRILO Reyes REYES 133 @gmail.com.
Okay. Then the court will is accepting the agreement as testified to on the record. The court is pronouncing you divorced. The court is granting Ms. Guzman's name change. Once I sign this divorce decree, then you will be divorced. Until I sign it, you're not legally divorced yet, okay?
All right.
All
Thank
right.
you so much.
Okay.
Best of luck to both of you.
Thank you.
Okay, so I have someone on here, Angie. Is that Miss Busby?
Yes, ma'am.
Okay, Miss Busby, can you please turn on your camera? Okay.
Hello.
And you're currently married to Derek Busby, is that correct?
That is correct.
Okay, one moment. Okay, so you and your husband currently have one minor child?
Well, she was at the time I filed, but she already turned 18.
Okay, did she graduate from
No.
high school?
No,
So she's still a senior?
correct.
Okay. Now, this is saying that you have a current child support order out of Tarrant County, is that correct?
That is correct.
Okay, so legally Tarrant County has jurisdiction over your daughter in this case at this time.
Okay,
So you have to file a motion to transfer. So in Tarrant County, so that it can be transferred into our court.
okay,
They have to release jurisdiction to us.
okay.
All right. So at this time, I cannot proceed with your divorce, ma'am, but what I can do is I'll set you for a status hearing, and I'm going to give you plenty of time. And that's February the 16th at 9:30. Between now and then, you need to make the arrangements with Tarrant County so that it can be transferred over here. Then you'll have to file a motion to consolidate that order once we grant, if we grant for jurisdiction to be transferred here. And then you can move forward with your divorce.
Okay,
And I'm going to give, if by some chance you have everything done before February 16th, let us know. We'll bring you in sooner. But if not, it'll be February the 16th at 9:30. And let's see how far you get.
okay.
All right. Okay. Good luck to you, Miss Buxby.
Thank you. You have a good day.
Thank you. You too. Okay, let me recall. CL 193359-I, Adriana Renee Peña versus Fernando Gomez. How much time do you gentlemen think you're going to need?
I would just say like 10, 15 minutes, Your Honor. It's not a very complicated case.
Okay,
I agree.
because it's gonna be 12.
Yes, ma'am.
All right, okay, go ahead, and we're here on Mr. Quintana's motion.
Yes, Your Honor. Roland Quintana on behalf of the plaintiff.
Go ahead.
Adriana Peña. Your Honor, this is a suit on a promissory note. In July 1st, 2014, the defendant signed a promissory note promising to pay my client $120,000. The note became due and payable July 1st, 2015. Although the defendant made payments, he did not completely pay the note by the due date. Currently, there remains an outstanding balance of $44,925.65. I don't think there's any dispute or any issues of material fact with respect to that amount, or the fact that the defendant has not paid that amount to my client. So we're requesting judgment in that amount, Your Honor. We're also requesting attorney's fees under Texas Civil Practices and Remedies Code, section 38.001. We provided notice to the defendant that he had an obligation to pay. He never paid, and thus we're here. My client has incurred attorney's fees in the amount of attorney's fees and court costs in the amount of $17,795.12. So we're requesting judgment in that amount of attorney's fees as well, Your Honor. And we're requesting interest at the rate of, prejudgment interest at the rate of 6% pursuant to Texas Finance Code section 302.002, which provides that legal interest at a rate of 6% a year on the principal amount beginning on the 30th day after the date on which the amount is due begins to accrue. Here, prejudgment interest will begin to accrue on July 1st, 2015, Your Honor. No, excuse me. The note became due and payable July 1st, 2015. So my client is entitled to 6% interest on the $128,000 beginning July 31st, 2015. And then, of course, Your Honor, we're also asking for post-judgment interest at the rate of 5% after this court enters judgment. It's my understanding that the defendant has alleged two defenses, even though in one of the requests for admissions I sent to them, they admitted that there were no defenses. And their defenses, Your Honor, are that limitations, the statute of limitations has passed. They're under the assumption that a suit on a promissory note has a 4-year statute of limitations. That is incorrect. It is a 6-year statute of limitations under Texas Business and Commerce Code, section 3.118. So again, Your Honor, there's no dispute that he signed the note, that he did not pay the note, that $44,000 and change remains on the note, that we provided him notice, he did not pay, and we're just requesting judgment as a matter of law, Your Honor.
Okay, Mr. Holguin, your response?
Good morning, Judge. For some reason, I don't know if y'all can see me, but I can't see myself. Not that.
No, we can't see you.
Yeah, it's black. And then when I stop video, it does show my name, but I try to restart it. But anyway, Eric Holguin for Fernando Gomez here, Your Honor. So one of the legal issues, and this is a legal issue, is whether we're operating under the 4-year statute of limitations for a contract or the 6-year statute of limitations for a promissory note. So if you look at Exhibit A, Your Honor, I'm going to argue that's not a promissory note. A promissory note is meant to be the functional equivalent of money, because these notes, and I represented many financial institutions before, and I can tell you, it is my argument that that's not a promissory note. Those notes get transferred from financial institution to financial institution, and they are the functional equivalent of money. They are meant to create a reasonable certainty of payment. If you look at Exhibit A, it is a 5-line Microsoft Word layman document drafted between the two individuals here. I argue that it does not amount to a promissory note. And as a result, we're operating under the 4-year statute of limitations. And that's important because, as Mr. Quintana mentioned earlier, the payment was due on July 1st, 2015. the lawsuit was filed 6/21/2019, right on the eve of limitations, and then Mr. Gomez was not served until after limitations ran on July 30. So it is my argument that creates a fact issue as to due diligence. There is case law. That as a matter of law, several months is not due diligence. I'm not arguing as a matter of law. I'm not moving for summary judgment on that issue. I'm just saying that creates a textbook fact issue as to due diligence. And as Mr. Quintana alleged earlier, we're also alleging laches. So I'll move on to the next point. I'm gonna object to his request for interest. He pled for interest under section of the Finance Code, section 302.002. And I have a case that's in this transaction, Your Honor, there was never any money advance, right? It was just I'll pay you back sort of deal. But under Bufkin versus Bufkin 259 Southwest 3D 343 out of Dallas, section 302.002 does not apply when there was no money that was exchanged in the transaction. There was no money exchanged in this transaction, and I argue as a matter of law, he can't collect those interests. And that's important because he's asking for, basically he's doubling the principal. I believe the debt is 44, and I believe he's asking for 43,000. So he's essentially doubling what he argues is an outstanding debt based on interest he as a matter of law can't collect. So I'm going to object to those interests. As a matter of law, he can't get them. And so he's asking for 17,000 and some change on attorney's fees. So I'm going to object to those attorney's fees because he's essentially accrued those attorney's fees chasing interest he as a matter of law can't collect. So I'm also objecting that how can his attorney's fees be reasonable and necessary if he's doubling the debt amount based on interest he as a matter of law is precluding from collecting. And then the final point, we didn't admit that there was no defense. Our defenses are very clearly laid out in our amended answer. There are affirmative defenses of statute of limitations and latchings, and we didn't admit to anything. So I know he's going to say that, well, they were deemed admissions because you didn't answer. I spoke with Mr. Perez. He has no recollection of ever receiving them. So if Your Honor would give me the opportunity, I'm fairly new to this case. If he did send them, I'll answer them, but I am asking for leave to, answer whatever discovery he sent. And lastly, there is a ton of case law on the issue of merit preclusive admissions. They're improper, Your Honor. So today the burden is on the plaintiff. It's not even preponderance. It's a lot more than that because every reasonable inference it's in our favor. But I know it's lunchtime. You're right. It's
okay.
12 o'clock. So I'll just leave it at that. I mean, Mr. Quintana, I appreciate him. He's worked well with me. So, our clients just can't come to an agreement. So he filed his motion. I filed my response. You've heard our arguments. And
Your Honor, may I respond though?
Yeah,
Sure.
let him finish and then you can do your reply.
So I was just going to say, we'll defer to your honorable discretion on how you want to move forward with this case.
Okay, all right. So go ahead, Mr. Quintana, your reply. Oh, I can't let you move forward without letting me see that beautiful dog.
She's right there, Your Honor. Her name's Zoe.
Oh my gosh.
I don't want to call her because she's gonna start biting me.
Yeah, we had a late start to the docket this morning because my dogs would not settle down. They're like children. It's like they know I need to start and they started barking like crazy. But okay, go ahead. Now I'll take your
Judge,
Mr.
Judge,
Hoffman.
very quickly. By the way, his dog chewed on my shoe, so I might have a tort against Mr. Quintana.
That's That's her favorite thing. Shoes. She loves shoes. You should see my closet.
Oh my gosh.
Yeah.
Okay, go ahead.
Respectfully, Your Honor, I disagree with Mr. Hogan on many grounds. First of all, he's raised many arguments now that he didn't raise in his pleading, so I don't think they're proper. With respect to the statute of limitations, that they're trying to say this is a contract. There aren't mutual promises. This is a promissory note. A promissory note has one requirement. There has to be an agreement to pay, a promise to pay. Here, the promissory note is very specific. It says that he agrees to pay. That is a promise, a textbook promissory note. In the statute of limitations, the reason they're trying to say it now that it's a contract is because they're trying to say it's a 4-year statute of limitations as opposed to a 6. Again, this is very clear that it's a promissory note, and the 6-year statute of limitations apply. But even, Your Honor, if we assume that it's a contract that doesn't have mutual promises, but it's still a contract, we complied with the 4-year statute of limitations, Your Honor. The suit by Mr. Hogan's admission was filed within the 4-year statute of limitations. Now, we had difficulty serving the defendant. It's not that we didn't try, we tried. And this court respectfully granted us a motion for substituted service. That's in the court's file. And as soon as it did that, we went and we served them the way the court permitted us to do. So even if we fall under the 4-year statute of limitation, Your Honor, there is no issue of material fact. We filed suit within 4 years. We tried to get him served, and we came back to this court within a month, and he was served as this court permitted us. And then Mr. Hogan is also asking that I'm arguing for an improper ground on interest. Your Honor, the statute is very clear. I don't know what this Bufkin versus Bufkin case is because he didn't cite it in anything, because he never raised that argument in any of his motions. But I'll gladly read it and provide this court a post hearing brief if this court will allow me to. But every case that I've read allows a 6% interest on promissory notes. What they're trying to do, Your Honor, is they're trying to get people to pay. And the people that say, well, this promissory note doesn't have an interest rate, so I don't have to pay, the courts have said, no, you have a 6% promissory, prejudgment interest rate. If you don't pay, you're gonna pay, pretty much. And then he's saying my attorney's fees. Your Honor, I didn't spend $17,900, $17,795 on researching that interest issue. We had mediation 3 times. The defendant refused or did not show up to 1 time. I had to file a motion for sanctions. I was, before this court several times, sent discovery, and the discovery was sent, Your Honor. We sent it via e-service. We've got proof that it was, served on defendant's counsel. And, one of them says, request for admission number 11 says, admit there are no facts upon which the defendant relies as a basis for any defense in this action. Now, all of a sudden, they're coming up with all sorts of defenses. He just doesn't want to pay, Your Honor. This poor girl has been waiting since 2015 to get paid. And I think it's time for her to get paid, Your Honor.
Okay, so if you want to supplement anything for me to look at prior to me making a decision, that needs to come to my office. Needs to be filed by December 3rd, because let's be realistic. Next week, it's Thanksgiving week. And so it'll be by December 3rd. And then I'll wait to see if you all file anything for me to look at. And if you want to reply or respond, Mr. Quintana, to anything, go ahead and feel free to do that. You can either send me case law, but if it's going to be the case law, then it needs to be case law that's referenced in the summary judgment. Or if you want me to look at something, then go ahead and file that by December the 3rd, number 1. Number 2, Mr. Holguin, if you're wanting for this court to make a decision with whether or not I would give you leave to answer an admissions, and that needs to be done in writing. So you would need to file a motion for leave so that you give Mr. Quintana an opportunity to respond to your motion, and then we'll set that for hearing as well. And then we'll go ahead and take up that issue with respect to the admissions. So I'm going to hold over I'm going to take it under advisement. I'm going to go hold over my ruling until after December the 3rd so that I can go ahead and see if you all file anything for me to look at. Now, you all have already tried resolving this 3 times.
3 times, Your Honor.
So normally I would have tried to send you back, but I'm not going to do that because it's already been 3 times. And I do recall very well the situation that occurred. And I know the defendant didn't live here, and so it was hard to get a hold of him. And then finally he showed up to that other hearing, and So I just encourage you to continue with your open communication with one another, but I do understand that at some point, there's not much else you can do except to just resort to the judicial process and see what ends up happening at the end, okay?
Well,
So,
I
go
appreciate,
ahead.
I appreciate your time, Your Honor, and at this time, I'll extend an olive branch to Mr. Hokie, and if he can get, a hold of his client, we've got to December 3rd to potentially resolve.
Sure,
this
yeah.
case, and, but, my client, like she told me, she's been waiting since 2015, so she would like some resolution in this matter.
Okay.
We'll be in
then-
touch, Mr. Quintana.
All right, then you all, I'll let you go and you all have a great lunch and have a happy Thanksgiving.
You too,
Thank
Your
you,
Honor.
Judge. You too.
Thank
May we be
you.
excused?
You certainly may.
Thank you, Your Honor.
Okay. Okay, did anybody call on number 17?
No, ma'am.
So we don't know if they were going to urge their motion for substituted service?
Let me just double check because I checked all the cases this morning. No, ma'am, there's nothing been filed. They should have.
Just ask them if they're going to be filing an order resetting hearing, please. And that'll conclude this morning's docket, and we